Coercive control looks close to being criminalised in New South Wales. The New South Wales government released a draft bill that has been released by the state's Attorney-General, Mark Speakman, for public comment ahead of introduction to Parliament. Joining me live is Hayley Foster, CEO of Full Stop Australia, Nicole Lee, activist and family violence survivor, Brian Sullivan, founder of Secura DV, and Thelma Schwartz, the principal solicitor at the Queensland Indigenous Family Violence Legal Service. Thank you all so much for joining us today. So, Thelma, I'm going to ask you, first of all, your thoughts on the coercive control laws, and are you satisfied with what's been put forward so far?
Yes, thank you. Thank you for having me. I'm coming from Cairns, and I pay my respect to the traditional custodians of the lands here in Cairns, the Gimuy, Walabra, Yidinji and Irukandji peoples. In relation to coercive control, I would be very concerned about actually ensuring that you are safeguarding against unintended consequences. And I've had the ability of being a task force member on the Queensland Women's Safety and Justice Task Force, and also looked at criminalisation of coercive control and any unintended consequences that may actually flow from criminalising this offence. And I'm particularly concerned about, well, how do you actually protect against what we see in our practice, my practice, the misidentification of the real victim of domestic and family violence, and police's responses in actually identifying who the victim is. And what we know coming out of the inquiry that's currently happening into police responses to domestic violence in Queensland is that there is a real issue in police actually understanding domestic and family violence and actually understanding what is coercive control, because they view coercive control as an incident-based response. They don't see coercive control as a journey. It is a spectrum that you need to look at, and you need to look at how that behaviour influences how a victim is impacted and affected, because it will not manifest in physical violence. It will manifest in a number of different forms, including the psychological and emotional impact. So those are my primary concerns about this. How has the Parliament actually looked at minimising unintended consequences, making sure that we're not seeing an overrepresentation of Aboriginal and Torres Strait Islander peoples who already have a very poor relationship with police, who are over-criminalised, and we know they're over-criminalised because we have our National Partnership Agreement on Closing the Gap, targets 10 and 11 on our young people and our adults that speak to our over-representation in jails. The other thing I'm keen to see is, well, how are you actually going to address the underlying causes of the behaviour? What is going to happen? Are we actually looking at what is actually happening within our correctional centres and the programs and how they're delivered within the correctional centres to actually change behaviours, get people to see that these behaviours are unhealthy and they're destructive?
Hayley, let's bring you in. Thelma talked about the spectrum of coercive control. Talk us through exactly what coercive control is and your thoughts on that spectrum from what Thelma was discussing.
Yeah, look, Thelma's spot on. We need to look at a whole series of behaviours, but the impact of those really. And look, the whole point of this debate about coercive control and criminalising it was to update the criminal justice system to actually reflect the lived experience of victims of domestic abuse. Unfortunately, we're still looking at it through an incident-based lens. So if you look at the draft legislation in New South Wales, for example, it goes through this shopping list of the types of abusive behaviours you might see in relationships, but it doesn't necessarily go to what is the context of that, what are the impacts of that, because you might have someone nitpicking or criticising or putting someone down in a relationship, and it might mean that, you know, they feel a bit bad about themselves, or you might be having those behaviours perpetrated alongside other behaviours, which makes that person feel completely subordinate, completely terrified, completely immobilised and dominated in that relationship, and if they step a foot outside the rules that their partner or their family member has set for them, it could very much be fatal. And look, that was the whole purpose of this, is that we recognise that, you know, after the death review in New South Wales that found 99% of domestic homicides involving intimate partner violence was actually correlating with coercive control behaviours and dynamics in that relationship. So look, it's not just about all forms of abusive behaviours, it's about the context of that, the pattern of abuse over time and the impacts that has on the victim.
Nicole, you're a family violence survivor. What are your thoughts on this bill brought forward and the laws that are being brought in for coercive control?
Well, as you said, as a family violence survivor and also a woman with a disability who is, a disability activist, and thinking of this and positioning this law for my community is that there are a lot of unintended consequences, like that was spoken to before, around misidentification of who is the perpetrator. Now, there's a lot of stigmas and stereotypes that are held poorly against disabled people, and that our carers and those in our lives are positioned in positions of power and positions of authority, and are kind of under this halo effect of never being able to do any harm, or that what they're actually doing, which is a form of violence, is then also viewed as being in their caring role, and therefore the way we come forward or what we're saying gets dismissed over the carer standing beside us or sitting beside us. You know, how disability is depicted in a courtroom, language around carer burnout, or mental health being used to discredit us when it gets to that courtroom, or even being used as a threat to stop us from going and seeking help is another thing that we're really concerned about right now. But as it stands at the moment, the draft bill before New South Wales only speaks to intimate partner relationships. So it's not speaking to all of the relationships that we have in our lives that involve abuse or where abuse can happen. It's not talking to formal or informal supports. It's not talking to family members. It's not talking to people in care homes, in institutions who are other residents. So it's leaving us in a lot of ways out of being able to access these things, or then being able to access family violence services, because it's not viewed as a form of family violence. And that's really disappointing to see a piece of legislation being drafted so poorly from the get-go, and then having these vague promises of we will come forward and retrofit it. And what we're saying is that we want a system that is safe for all victim survivors to be able to go to, and alternatives to simply just a criminal justice response for victims who access, who don't feel safe going down that criminal justice pathway, who have been harmed by courts, who have been harmed by police, that still want help and still want their experience to be validated and still want a sense of safety and to be able to rebuild their lives. And a piece of legislation at this point in time cannot do that. It does not speak to the system responses that are needed. It does not speak to inadequate housing options. It does not speak to the rampant poverty that most of us are left in to then rebuild our lives. And as somebody who has been through this court process, I've received that justice that everybody says that a victim survivor needs and wants and should be seeking. And I can tell you right now, the damage on the other side of that system was not worth what I went in there. It is not justice, and it does not feel like justice. It did not rebuild my life, and it did not rebuild the life of my children. It did not address the poverty that I had to come home to. It did not address the severe forms of mental health that I had incurred in those 10 years of abuse, or that my children had incurred. It's not speaking to a whole of system response that we actually need to address the problem. And if we look to overseas and we look to the responses that have been happening overseas, is that we have been seeing a drop in reporting rates for people. So, the fear that we potentially can push people who've had bad experiences with the system further away from help-seeking behaviour is something that I do not see any strategies being spoken of or put in place to mitigate any of these things. And these are really, really concerning issues that we, ahead of laws being brought in, had expressed concerns of, and we are now watching actually happen in real time. for survivors and experts who have said slow down, heed the warning from overseas where Scotland have said do not rush this, to watch this being rolled out and wanting to be implemented and training introduced within 18 months is way too fast. And it is disappointing to see this being rushed in the face of warnings from other jurisdictions and in the face of experts who speak with and for diverse communities, who are experts from diverse communities that are saying this will harm us, this will harm our women, and this will push our people further away from seeking help, which is something we do not want to do. And this will not address pathways to seeking help. It will not address pathways to police. It will not address poor police responses. It is a long-term solution that is needed, and this is a very small one piece to a major puzzle, to a major picture that needs addressing across the board, from community attitudes to gender inequality to poverty and poor access to services for people across multiple different communities, being that disabled, First Nations, CALD, people with mental health conditions who are treated very badly in a courtroom. And until we break down that harm in those courtrooms on that finite response that not many of us actually get to, I do not believe at this point in time we have a system that is sophisticated enough to handle a law such as this. And we do not have a system that does not create immense amounts of harm that outweigh the benefits, where the benefits outweigh the harm in which we incur in going into that system. And until there is evidence of those things, it is going to be very troubling, and we're going to continue to push governments to not just simply write a piece of legislation, but to do all the moving parts that need to be done in conjunction with us to safeguard communities from being harmed with this law.
Brian, what are your thoughts? Do you think this has been too rushed? You train people, work with perpetrators for more than 20 years. Is it being too rushed in your opinion?
Well, I think so. I concur with what everyone has said previously. What we're dealing with here, I think, is an attempt at some sort of global response to domestic and family violence that we feel on the surface is going to solve the problem. But the reality is it's a liberty crime, and it's a crime that needs to be addressed. Whether it has to have its own legislation in and of itself is very debatable, I think. I don't think the jury is finally come to terms with that. We have domestic violence laws now which include control in their definitions. This is in Queensland. We have strangulation laws, we have sexual assault laws, we have deprivation of liberty laws, we have torture laws and stalking laws. I think, adding another layer of legislation to what is not being addressed adequately already may in fact set us up for failure. And by failure, I'm talking about failing victims. And we've spoken about justice today. Is this going to actually provide justice for victims, or is it going to muddy the waters with the unintended consequences that have been spoken about before? Is it going to be a further avenue that perpetrators can use to further abuse their partners? I don't think we've really thought this through clearly enough, and the implications of this law. It's one thing to have the symbolic value of legislation. It's another to be able to ensure its operationalisation and its being effectively dealt with in the actual the frontline trenches where this is happening. I think the understanding that it gives us, and there is an education and an awareness around coercive control now that wasn't before, is that domestic and family violence is obviously far more than physical, and it's far more than one incident. It's a whole pattern and a dynamic and a strategy that a perpetrator uses over time. I think it's given us that realisation. But I think we also have to understand that coercive control is not anything new. It's actually all of domestic and family violence is about coercion and control.
Thelma, what are your thoughts on that? Do you think the system is in some ways broken? Can the system handle it?
Having sat on the task force in Queensland, our second report, Hear Her Voice, Report 2, examined sexual violence through the lens of women and girls' experience through the criminal justice system, both prior to entry, during the criminal justice system, and then when they came out. It is clear to me, and that 188 recommendations made by the task force, including myself, that it is a system that is not capable of adequately responding to victim survivors of domestic and family violence and sexual violence. These are not safe places. These are not trauma-informed spaces. These are spaces that, given the underlying realm of the rule of law and a defendant's right to a fair trial and other rights, preference a defendant and forget with respect the victim's place in this and what justice looks like for that victim when she finally has the courage and the strength to bring a complaint to police, to agitate for that complaint to be actioned and then brought through the court system. It's not adequately prepared. It cannot properly respond to a victim's needs. So I would suggest, in relation to what New South Wales is doing and what we learnt from Scotland, before they implemented these laws, there was an implementation plan, which is part of the heart of what the task force recommended, what the Queensland government has now agreed to in the 85 recommendations specifically aimed at government before we introduce coercive control as a law in Queensland. You need system reform. All of those wraparound intersectors that are part of this need to be brought into this. You can't just be relying on outcomes to change, given that you've got a strengthened or bolstered police response and a court response, without looking at what are the inherent deficiencies and gaps. And there are gaps here. And I think what I'd like to see with New South Wales is having a look at the broader system response here, because it's not those two components. They play a very big part in this. But if you want to stop the rate of recidivism, you actually need to get to the heart of why do people think that it is acceptable to engage in coercively controlling behaviours, which then stem into the broader domestic and family violence spectrum. And I'm looking at now in Cairns, we've had the death of a 5-year-old, and this is in a family violence context. And I look at this, I look at all of the deaths that we seem to see each week across Australia, and I wonder, what the hell are we getting wrong here?
Yeah.
This is not just about policing and the courts. This is broader, and it needs to stop, and we need to address it.
Thelma, I'm so sorry I have to interrupt because I'm being told to wrap up, but I just wanted to get to 10 seconds from Hayley, Nicole and Brian to wrap it up. So, Hayley, do you want to just give us your final words on this? And I wish we could go longer, but we can't, unfortunately.
Yeah, no worries. Look, all eyes are on New South Wales at introducing the law first, right across the country. I have to say that the first exposure draft has not got it right. It's not even close. We have until Wednesday to provide feedback, and there are fundamental problems with this draft bill. We would urge the New South Wales government to reconsider the time frame, and we are well and truly ready to work with you, alongside you, to make sure that this is an effective law with all the systems that wrap around it.
Nicole, we've got 10 seconds to get your response as well.
Well, when it comes to disabled people, it's understanding all the areas in which we and the environments in which we do encounter coercive control and abuse, and understanding that coercive control is a form of every form of domestic and family violence. It is not something that is necessarily segregated on its own. And finally, is that, criminalising alone is not something that is going to be acting as a deterrent, and that is something that has been noted overseas. And that there has to be other options around, shifting of community attitudes and looking at issues around gender inequality, and looking at how disabled people are depicted in courtrooms and how unsafe they are, and the ways in which we are spoken about as well.
Thank you. And Brian, just quickly.
I think the system isn't broken. I don't think the system has ever worked. So we need a new system, and if it's going to bring in coercive control, that has to be operationalised and defined very, very clearly. And then, of course, we have to do the education of courts and police, etc. And then what do we do with those convicted? There have to be resources available to deal with the aftermath.
Sorry to wrap it up, but we have to go to a break now. Thank you all so much for your time. And if this story has raised any concerns, you can contact the Domestic Violence Helpline on 1800 RESPECT. After the break, Cowboys coach Todd